Welcome to the Roetzel Health Law Hotspot. Health Law Hotspot is a podcast for physicians and health professionals that covers the legal issues and trends that affect the healthcare industry.
Hi, everyone. Welcome to the Health Law Hotspot. I'm Ericka Adler, shareholder and leader of our healthcare practice at Roetzel and Andrus. And today I'm joined by Todd Erdman from Todd Erdman PC. He is a great dental lawyer and friend, and I've worked with him for many, many years on many transactions, and I'm really excited to have him here with us today. So welcome, Todd.
Thank you very much, Ericka. I'm glad to be on today.
So today we're going to talk about something that Todd and I work on often together, which is a dental transaction in terms of buying and or selling a dental practice. We both work with a lot of dentists and we see a lot of the same questions coming up, a lot of the same confusion, a lot of the same issues. So I thought it'd be really helpful for our clients that are going to be listening to this to kind of talk through the process of buying a dental practice, or selling a dental practice, some of the issues that arise, things to watch out for. And I know Todd has been doing this for 23 years, I think you said. You've seen a ton of things. He actually does way more dental stuff than I do. So this will be kind of interesting. I'll learn as well. And so let's just jump in right away. And why don't you tell me, Todd, what do you think the first piece of advice is to somebody who's looking to either buy or sell a dental practice?
Well, first of all, thank you again for having me on today. And it is like talking to a friend. So this is fun. I think the first step really is to assemble your team. What a lot of people think is they can use their uncle, who's a personal injury attorney, to help them buy a dental practice, or they can call their neighborhood banker who helped them with their mortgage to help them finance the purchase of a dental practice. It is a very specific area, and everyone involved in the transactions it's very niche. And so what I always tell people is if you want to be at the table and have a level playing field, you want to have a dental specific team around you. So the main players, in my opinion, are the attorney, the accountant, and the banker. And when you have dental specific people in those three areas, you're really putting yourself ahead of the game, and you're going to have people that are be looking out for your interests. They tend to care about the dental community because that's what their category is, working with dental. So if they want to do well, they have to have a good reputation. And so they're going to look out for their clients. So having a dental attorney, the CPA that can look at the tax returns and look at the cash flow and make sure that what they're buying is going to be a good investment. And then the bank is critical because if you talk to your neighbor lender, they may want to have a mortgage on your house. They may want guarantees from your parents. That's just not the way it works in dental. Most of the dental clients I work with are getting 100% financing. There is no guarantee by any relatives. And they're also getting working capital funds. And the process is so much easier because they're dental specific. So that'd be the first step. Do you want me to jump into the second step, or did you have a question about that?
No, go ahead.
All right. The second step is probably the most difficult, and that's finding the practice. And people always ask me, how do you find the right dental practice for you? Obviously, it's very specific to each person. Everyone's different. You may want a suburban practice. You may want an urban practice. So the first thing is to figure out what you want. And when you have an idea of what you want, then you have to start talking to the various practice brokers. You want to start looking in Dental Town, the Chicago Dental Society magazine, and word of mouth is also a great way. A lot of the people, they have common interests. You might be in a study club. Your study club is usually geographic. So you can find a practice good for you based upon talking with other people.
And also, like I match up people all the time. I might have somebody who I know has been looking to leave a practice and buy one of their own, or looking to sell and they want to retire. So I often make those connections. I'm sure you do. And so your team that you just mentioned are really a good place to start as well, because we all kind of know each other and we know the people who are running practices or looking to buy or sell them. So it may be easier than you think sometimes to make that connection as well.
100%. Just calling the dental specific banker or attorney or CPA, you might say, I'm looking for something in the south suburbs, and boom, they could have someone that literally just lost a deal, or maybe someone who just called them and said, hey, what do I do when I'm ready to sell my practice? Right. So that's an excellent source of finding a good practice. But if that fails, then there are plenty of people out there that are in this business that are helping dentists to transition. So then when you find that practice that you like and you see it and you think it's a good fit, then you're starting to lean on your team. You're leaning on your CPA, your attorney, and your banker to help you review the practice, to make sure that it fits with your goals, that the cash flow makes sense. You may love the neighborhood, but if the rent's really high and the production doesn't really commensurate with what you need to take home, even though it might be a perfect practice visually, what you're really buying is the cash flow and the opportunity. So there are some practices that don't have the best equipment, may not be in the most ideal neighborhood, but they're just, killing it. Let's just be honest. They're doing really, really well.
Right.
So that's kind of where I like my people whenever possible.
Right. No kidding.
So you find that practice and you have your team, kind of tear it apart in some ways and then build it back up. And then if you are able to reach a price, that's when you actually engage your attorney to start working. One of the questions I get a lot of, and I think you and I have talked about it, Ericka, is do you do a letter of intent? What is a letter of intent? Let's start with that. A letter of intent is kind of like a mini agreement. It's almost an agreement to agree. And it sets forth a lot of the basic terms of the transaction. And some of the people I work with, whether it's a broker or a consultant, they really like them. They want a letter of intent, a couple pages long, and have everything set out for you. Some examples of what is in a letter of intent are the purchase price, the closing date, which obviously is important, what assets are included, what assets are not included. Some practices have CEREC machines, and sometimes the buyers don't want them, and the sellers would rather just find a way to sell it themselves. So it's important to know what's included and excluded. Another item I see excluded often are lasers. People get the lasers, they get heavy duty training, and therefore if someone's going to buy that practice with the laser, they really have to have that training, or the laser may need to be excluded.
Right.
And then the post-closing work by the seller is really important. Is the seller going to be working after closing for a period of time? How many days a week? Are they going to be paid 35% of collection, less 50% of lab, or is it going to be something else? And another reason that's important is, does the practice support 2 doctors? So if you have a practice, let's say it's $500,000, and you have a doctor who wants to work full time right away when they buy the practice, it might be difficult to have the seller stay on for very long. So having that kind of ironed out is a good thing usually. Another thing I see in these letters of intent are an exclusive dealing clause, which says, hey, if I'm going to assemble this team and I'm going to be paying my attorney and CPA and consultants to look at all this information, and we're going to the dance together, right? I don't want you looking. Let's work exclusively for a little while. And it could be anywhere from 30 to 45 days. So it shouldn't kill the seller, and the seller shouldn't feel like they're cornered. It shouldn't be 90 or 120 days where, oh my gosh, now it's going to be next summer before they can sell something else.
Right.
But it's a period of time where the buyer doesn't buy and the seller doesn't sell to other people. Confidentiality is important. Not only the documents that are being shared, but also just the very fact that the practice is for sale, because most people don't want that out there.
Right. Absolutely.
And then contingent.
Yeah. Well, so let me ask you just a couple of questions though. So, we'll talk, I know there's definitely more things to include in a letter of intent, but unfortunately, a lot of people come to me, or you, I'm sure as well, and they've already kind of signed one. And sometimes I find like some important terms are missing, like that exclusivity period. I've had people think they had a deal, start working on it, and then it gets sold under them to someone else, right? I have seen just a lack of clarity. I've seen one that has like 3 sentences on it and it's signed, and it just is inadequate to get the job done. So I think, kind of one of the points I want to make is that it's not just, we agree to sell, here's what we're paying. It does have some more terms. And if you do spend the time on the letter of intent, then actually doing the documents becomes easier as well, because you just kind of fill in the terms that have been agreed to. So that's one thing I want to mention. The second thing is, and you kind of mentioned this briefly, was when you're buying a practice, if you work with a broker, right? A lot of times brokers will be the ones rather than lawyers that give you that letter of intent or that help you with that letter of intent. And you and I will agree that there's some brokers that are better than others, right? And their forms of documents some are better than others. So I guess the one thing I would always say is I like to have my clients, even if they're using a broker, I'm not trying to replace the broker, but to at least run it by me first before they sign it, because it is a document. And I would hate for them to not include something that was pretty important in there because it wasn't part of the form. And I find like a lot of brokers, they have a form. And if it's not kind of one of the 3 or 4 things that's on there, it doesn't get captured in the LOI because it wasn't on the radar, so to speak. So, I think when we're talking about an LOI, I still think it's worthwhile to always not necessarily do it by yourself, but run it by your lawyer just before you sign it, because it can definitely set the tone for the rest of the deal.
100%. And I know some brokers that won't even do letters of intent because of what you're describing, that they're concerned that the parties will spend so much time on the letter of intent and they can end up in arguments that really aren't necessary because those discussions are happening before the attorneys are involved. And so sometimes I see a lot of success where the parties just come up with the price and that's kind of it. And then the lawyers jump in and they either create a letter of intent or they just go straight to the actual binding documents. And I have a broker that really won't do letters of intent. I must say his batting average is really high, partially because he gets dental lawyers involved, but also just because he really stays involved and makes sure everyone's trusting of each other. They know that the deal is on the right path. But like to your point, some of these letters of intent are just awful, and they can actually mess up the deal because it creates, distrust, because people are like, well, wait a minute, that's what this says, but now we're saying that. So I agree.
Right. I mean, all these brokers are totally different, but they do get paid based on the closing price typically, right? And so there's a lot of urgency for them to get a deal signed. And, doctors and dentists, I don't know anything about dentistry. I'm not sophisticated when it comes to teeth, obviously. And, but dentists are not sophisticated when it comes to legal documents usually. So it's very easy for somebody they trust, like a broker or another third party that might be playing a role, to say, this has everything you need, just sign it, And typically even though most of them will either not be binding or say they're not binding, it is essentially supposed to be a meeting of the minds. It does create a lot of bad faith to say, oh, I regret having agreed to that. Now this is what I want it to look like. So there is a little bit of, an expectation that when you sign that letter of intent, you're going to honor the terms of it. You're not going to suddenly change your mind. And so if you go talk to somebody after you sign it and say, well, oh my God, why would you agree to that? That's terrible. You know what I mean? It kind of puts everybody in a very tough spot. And I've had that happen. And, we try and work around the agreements that have been made. But sometimes people just make bad deals because they don't know any better.
100%. And that's why that team approach to me is so critical. Because if you talk to the attorney already before you find the practice that you want, you already know what the step one is. You already know that you're going to have the document, you're going to have the tax returns looked at, and then you're going to call me, call you, call whoever it is that sounds specific to talk about the transaction and make sure it's the right fit for them and the documentation is going to be okay. Because again, in my opinion, there's no perfect way. There's no absolutes here. Some people really like each other. They trust each other. They skip the letter of intent. And I've had plenty of success. While others would like to have that letter, but as long as the team is there, the opportunity is way higher chance of success.
Absolutely agree. Perfect. All right. So keep going. I didn't mean to interrupt. You were going to talk about some other things that you think are really important in that letter of intent.
So some other ideas that buyers and sellers should both understand are that, when you find the practice and you go there and you meet and you like what you see and you've kind of reached a price, there's still some contingencies, some things, some conditions that have to be met before the transaction is going to actually close. The first one is usually due diligence. And a lot of people probably heard that term. They don't know what it means. Due diligence just means review. It means understanding and taking the time to make sure you know what you're buying. And that often includes, as I said earlier, having a look at least 3 years worth of tax returns and some profit loss statements from this year, and possibly doing a chart audit. And that's where having a good dental consultant can be really helpful to go in and actually look at the charts. And so and making sure you know what you're buying. So that's part of it. The financing is key. You have to be able to get the loan to buy the practice. So if a bank looks at it and says no, everyone has to understand that this isn't the buyer bailing on the transaction.
Right.
The price might be too high. And then the lease. And I think, Ericka, you and I talked about this off camera. The lease is becoming a bigger issue. And a lot of doctors ask me, Todd, what the heck's the lease have to do with me buying a dental practice? The answer to that is you have to have a place to operate. And when you purchase a practice, there is always going to be real estate involved. Maybe you're buying a commercial condo. Maybe you're buying a single tenant building, lovely, which has a whole nother set of things we can talk about maybe another time. But more often than not, you're leasing the space from a landlord. And so there's going to have to be a document, a lease that you're either going to be assuming from the seller, or you're going to be negotiating a brand new lease for yourself. And so that is going to be absolutely a condition, and it's going to take some time and some patience, because what I'm finding is landlords are being a little bit more difficult than they used to be. I felt that before COVID, I think they were pretty easygoing. A lot of landlords got burned by COVID, and so now they're being more and more careful. And some of them are requiring that you as a seller actually remain as a guarantor while the buyer takes over the practice, which is kind of a painful thought, because when you sell your business, you're like, okay, I'm done. And landlords are saying, no, if this new buyer of yours doesn't pay the rent, you may have to pay it for them. So that's definitely one of the conditions.
Right. And that is really tough. I mean, a lot of our clients will use like a lease broker to help negotiate some of that. I mean, again, it's one of those things where you practice dentistry, you don't necessarily have experience in negotiating a lease. I recently had a guest on here who spoke about the benefits that a lease broker brings. And one of them, from his perspective, is that there are so many reasons right now for a broker to want to play ball, so to speak. You want to lock somebody into a long-term arrangement, even somebody who's just up for renewal, right? Why not make a deal with them? Because, that way you have a long-term arrangement as opposed to somebody deciding, not to renew or not to stay much longer. There's just a lot of wins for both sides to kind of work together, and the broker kind of plays that role. I certainly, don't want to get involved in negotiating business terms, and the dentist is often busy practicing dentistry, right? So that broker can play a role. And one of the things you and I have recently experienced in a transaction was that the landlord refused to talk to the broker, which was a really unusual experience, because they most often do help us kind of get stuff done, right? But in this case, they refused to, and they almost seemed like offended that they had been contacted by a broker, and they really created a hiccup in the transaction, which is otherwise completely ready to go, right? So, I mean, the lease and the lease is a contingency to closing. So if we have everything else done, the documents are done, the bank has approved, but we cannot get that lease deal done, we have no deal. And that's why it's such an important piece of it, right?
100%. And what I've been saying and trying to implore upon the brokers that I've worked with is, please, when you call the landlord, introduce yourself and explain that we'll need to have a side arrangement for a commission, because listen, you're a licensed professional. I respect that. You're there to negotiate a long-term lease, which the landlord will benefit from. And they just have to understand they have to pay a market fee for that to happen. A lot of landlords agree to it because they understand the value of, you have the senior doctor and then you have the junior doctor, and junior doctor could be there for 30 years. And that's a massive plus for this landlord. So I think there's value there. But if the landlord won't pay, then learning whether or not that'll happen as early on in the process is great, because then if they won't, then you just have to move on to some other type of negotiation, whether it's direct with the lawyers or with someone else. But every landlord's different. And even if you negotiate that, they still sometimes will cause trouble.
Right. And again, it's such a key component to closing a deal. Now, sometimes I do have existing dental practices that just kind of buy up goodwill, patient records, and equipment, and they don't really want the lease. That actually is not that common. But are you seeing more of that now? Because we have been working with a lot of clients who have formed DSOs, as you know, and their goal really is to kind of pick up the patients, from various practices and kind of grow. So I am seeing a little bit more of people buying the practice without taking over the lease. Have you seen that at all?
I have. The merger market is picking up a little bit of steam. Some people are in buildings that are older, their equipment's really old, and they're having a difficult time selling. Perhaps they held onto the practice too long, and so the cash flow just isn't there to support the overhead. They can afford it because they have no loans, and they're just kind of working for fun. It's almost like a hobby, a couple days a week,
Right.
But then when the buyer comes in and they're taking over the lease payments, they have to, borrow the money to buy the practice.
Right.
It's too heavy for them to hold. So I am seeing a certain amount of that. I know DSOs love it. I will say, as a buyer, there's probably nothing more valuable than a merger, because you're not undertaking additional overhead. All you're doing is taking on additional income, provided that the patients stay. So the key is to make sure that that doctor comes over for a while, at least a hygiene cycle or so, and helps to make sure they stick around. But no, I do see those. And the nice thing about that is it takes the landlord out of the equation, provided the selling doctor is on a month-to-month lease or doesn't have very much longer on their term. Because if you have 3 or 4 years, a merger is difficult.
Right. And, speaking of a month-to-month lease, that can be kind of dangerous as well. We've had dentists that have been in buildings for a very long time, and they're suddenly, the building sold, and they're told, they got to move, right? And things like that. You're so tied to your location in terms of your reputation, your patients, they know where to go. They've been going there for many years. And unless you very quickly can pick up something close by, patients, how far they're willing to travel to stay with the same dentist is one of those mysteries, right, of the world. So, it's really important also, just keep an eye on your lease. I'm really sometimes surprised by dentists who find themselves in a month to month, and they're just assuming I know the landlord many, many years, I'm not worried, only to find out, they pass away and they're, somebody else now owns it or takes over or whatever it is. So you got to be smart. If you have a business, you need to make sure that the business stays in business for as long as you want it to, not somebody else, right? And so that's one of those things to, just as a side note, to keep an eye on.
I completely agree, because it's a scary notion to think that the owner of the building, you're on month to month, you've been there for 15, 20 years, 30 years, but then they sell it or their children take over and they have different ideas. So the idea of a month to month lease for a dentist is a little bit scary. And on a month to month that's listening to this, I would definitely consider, talking to your landlord or talking to your attorney or broker and getting yourself at least, 2, 3, 4, 5 years. Because even if you're thinking about selling soon, your buyer is going to need a lease. So unless you're going to do a merger, if your practice is, if it's really not super active, then a short-term lease is better. But if it's active and profitable and you want to sell it, having a lease is a good idea.
Absolutely. All right. Sounds good. Okay. So let's talk then. You've got your LOI signed. What happens next?
So you have your letter of intent signed, you have your bank involved, you have your attorney. The next step really is to draft the documents, to get the legally binding documents in order. I typically, as buyer's counsel, like to draft the documents. I think it's better that way. You don't want 2 people to have to comment on documents. It makes for more time, more effort, more legal fees. So when the buyer says, here's the piece of paper that I would like the parties to sign, if you sign this, seller, we're ready to go. That to me is much easier, because now all the seller's attorney has to do is review that document, discuss it with their client, and come back with comments. If you use a third-party document, if a broker or a third party drafts the agreement, now if you're the seller's attorney, Ericka, and I'm buyer's counsel, we're both having to review the same document, and the thing can go in 8 million different directions. So my recommendation, usually buyer's counsel draft the agreement. You go back and forth, you discuss it. And when you reach an agreement, during that time frame, you then talk to the landlord. A lot of times it can happen at the same time. I like to start that process with the landlord once the document is, let's say, 80% complete. If we don't have any major issues, some sellers' lawyers don't like that because they're afraid of confidentiality. They don't want to talk to the landlord until the contract is 100% done. I respect that, but people just have to understand, from a timing perspective, that deal is going to take longer. So if you're trying to close in 30 days, you really need to get the lease going. If you have 60 or 90 days, you're not worried about it. then you certainly can wait until the asset purchase agreement has been signed. But that asset purchase agreement getting signed, the landlord getting on board with whatever the new arrangement's going to be, once that's done, then you got to make sure the banker's happy and will bring the money to the table. And once that occurs, you close. And one thing I'll mention is more and more closings now are virtual. I used to go to every closing. I'm guessing you did a fair amount as well, Ericka. I haven't been to a closing since COVID. And frankly, my clients are saving money because if I don't have to drive to Aurora from Wheeling, if we're doing everything by the internet, if we're doing everything with Adobe Sign or DocuSign, it gets done, same thing is accomplished. And usually the broker and the clients will be at the closing, they shake hands, and then they introduce them to staff and all that good stuff. But that's usually, the next step is when the documents are done, you close, the bank wires the funds, and you move forward.
Right. I absolutely agree. And I think, the one last thing I'll mention, because this sometimes is an issue of contention, is making that announcement to staff. Just like with the landlord, you don't want to say anything too soon. You've got the buyer that's really interested in some of the staff, but you've got the seller who doesn't want the staff to know because they're afraid the staff might leave or be unhappy. But on the other hand, the seller needs to know from day one they have people who are going to be working there running the practice. So that also can be an issue of contention that really does need to get worked out, as well as the method by which patients are going to be informed of the deal. Now, typically the doctor who's selling will stay on for some period of time to kind of transfer the goodwill and make the introductions. So that definitely keeps the staff on board, usually for some period of time. But that's always a worry of my clients, when we're doing these transactions, is, the timing on talking to staff.
No, I agree. And my attitude as a seller is staff should not know anything until the deal is closed and funded. There's really no gain by the seller to tell anytime sooner. If you tell them even 3 days before the closing, if the bank is delayed, if there's a problem, now what? Do you introduce them as if they own it? Or do you have to now explain there's been a delay? Now is the staff nervous? Are they worried maybe aren't secure? Now, from the buyer's perspective, I understand the idea of a little bit of warning. It's comforting to know what's coming and that they're going to get to keep their job. But I will say, with a good broker that's been doing this a long time, they are kind of magical. They can do a really good job. And if they know what they're doing, they know how to handle the day of closing, they know how to make those introductions and to make people feel good and to help with the transfer. And as far as, keeping patients and keeping staff, one thing I'll say, if no one else that's buying a practice remembers anything from this conversation, my recommendation is don't change anything for a hygiene cycle. Leave everything alone, leave the signage alone, keep the artwork alone. I don't care. Even the people that provide the water, the water fountain, I don't care. Just everything should be the same because no one likes change. And you're already having this huge change of a new owner. So the last thing you want to do is change your patient software, right? You don't want to change anything that's going to make the staff's life more difficult or your own life more difficult or the patient's. Keep it the same, give it 6 months. And then at that point, now that you've gotten in well with the staff, the patients, people know you, if you hate something, make the change.
Yep, great advice. I think having a smooth transition is kind of what lets the buyer maintain that practice successfully. So I think that's absolutely key. So maybe what we need to do is get one of those magical brokers on here and find out their secrets and some tips they may have. So maybe you'll come back and you'll bring a broker with you and we'll talk about, some of the little tips they have to make a transaction successful. All right. So any final words here, Todd, on having that successful dental transaction?
Have your team and do it as soon as you can, because one thing that's universal, everyone says they wish you did it sooner. So when you're ready, when you have the itch to buy a practice, just do it. You'll be happier. You'll make more money. You'll be much more fulfilled having your own business. So I'd say pull the trigger when you're ready.
Awesome. Well, thanks, Todd, for being with us today. Everybody, Todd Erdman, and we'll share your information when we post this. And thanks again for joining us. This is the Health Law Hotspot. You can check out more of our podcasts at ralaw.com, and we'll see you next time. Thanks for joining us.
The Roetzel Health Law Hotspot is made available by the firm and its attorneys for educational purposes and to provide general information, not to provide specific legal advice. Use of the Roetzel Health Law Hotspot does not create an attorney-client relationship between you and the firm or any of its attorneys. The Roetzel Health Law Hotspot should not be used as a substitute for competent legal advice, and you should contact an attorney in your state about any legal needs or questions you may have.